I'm Ben Meiselas from the MeidasTouch Network. Judge Aileen Cannon just issued her first substantive order in the criminal case brought by Special Counsel Jack Smith and the Department of Justice against Donald Trump in the Southern District of Florida Federal Court for the willful retention of national defense information, conspiracy, making false statements, and obstruction of justice. I want to first read the paperless order that was issued by Judge Aileen Cannon. Next, I want to talk about what it means. Third, I want to talk about its implications with respect to Aileen Cannon's recusal. And I'll just get to the point right here and say Judge Aileen Cannon is not recusing herself. So what happens next with respect to Special Counsel Jack Smith? I want to talk about the recusal statutes, 28 U.S.C. 455 and 28 U.S.C. 144, which are the main recusal statutes under federal law. What does Special Counsel Jack Smith do next, and where do we go from here? So let's address all of those issues. First, let's look at the paperless order just issued by Judge Aileen Cannon on Thursday, June 15th, 2023, which states as follows: paperless order. On or before June 16, 2023, all attorneys of record and forthcoming attorneys of record shall contact the Litigation Security Group of the U.S. Department of Justice, if they have not done so already, to expedite the necessary clearance process for all team members anticipated to participate in this matter, and thereafter file a notice of compliance no later than June 20th, 2023, signed by Judge Aileen M. Cannon on June 15, 2023, and entered on the same date. So this case is brought under the Classified Information Procedures Act, CIPA. Of course, it involves Donald Trump's theft of thousands of government records, which also includes classified information, top secret information, sensitive compartmented information. And so in any type of case involving the Classified Information Procedures Act, there is a process that the defense attorneys must go through to ensure they have the appropriate clearances and that they sign the appropriate documentation in order to be able to review the records that are at issue in the case. There's an approval process, there's a paperwork process, and that has to take place. And here, Judge Aileen Cannon ordered that take place on an expedited basis, that Trump's lawyers contact the Litigation Security Group of the U.S. Department of Justice to fill out all of that paperwork and then file a notice of compliance within the next 5 days of this order, on or before June 20th, 2023. So the implication of this order, though, is deeper than just what it states, because the fact that Judge Aileen Cannon is issuing orders demonstrates that she is not going to self-recuse. That was an option that she had. It was an option that she lawfully should have pursued. But as we know about Judge Aileen Cannon, in the prior instance back on August 8th of 2022, in connection with the search warrant executed at Mar-a-Lago, she asserted jurisdiction over a case she had no jurisdiction over in the first place at all. And then she was overturned twice by the 11th Circuit Court of Appeal. So she clearly has a penchant of violating the law and trying to assert jurisdiction over cases she should not be involved in. So under 28 U.S.C. 455, disqualification of justice, judge, or magistrate judge, she should have disqualified herself right away. Let me read for you what the statute is. A, any justice, judge, or magistrate judge of the United States shall disqualify himself or herself or theirself in any proceeding in which his, her, or their impartiality might be reasonably questioned. B, they shall also disqualify themselves in the following circumstances: where they have a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceeding. There's other subsections in that statute, but those are the relevant ones here. And just by reference, a federal judge presiding over a case involving Ron DeSantis self-recused because a distant cousin had shares of Disney stock and they didn't want to have an appearance of impropriety. So the judge self-recused in that matter. And here, the very fact that Donald Trump appointed Judge Aileen Cannon would create an appearance of impartiality under 455 subsection A. And then you add on top of that the fact that she was found to have previously unlawfully asserted jurisdiction back in 2022, and she was overturned twice by the 11th Circuit Court of Appeals. She should have self-recused. So the fact that she didn't self-recuse, and we know that because she's issuing orders right now, I think Special Counsel Jack Smith was waiting to see if she would self-recuse. So that was kind of step one. Now she hasn't self-recused. So what happens next? In addition to 28 U.S. Code 455, which I just read, there's also 28 U.S.C. Section 144, which also involves the disqualification or recusal of a judge. Let me read this for you right now. Whenever a party to any proceeding in a district court makes and files a timely and sufficient affidavit that the judge before whom the matter is pending has a personal bias or prejudice either against him or in favor of any adverse party, such judge shall proceed no further therein, but another judge shall be assigned to hear such proceeding. The affidavit shall state the facts and the reasons for the belief that bias or prejudice exist, and shall be filed not less than 10 days before the beginning of the term at which the proceeding is to be heard, or good cause shall be shown for a failure to file it within such a time. A party may file only one such affidavit. In any case, it shall be accompanied by a certificate of counsel of record stating that it is made in good faith. And notice 28 U.S.C. 144 deals with actual bias, actual prejudice. 28 U.S. Code 455, which I had read a little bit earlier in this video, deals only with the appearance of impartiality, the appearance of impropriety. So courts read these two statutes together, though. So now that Judge Aileen Cannon has not self-recused under Section 455, under the combined force of Section 455 and Section 144, I think Special Counsel Jack Smith has an important decision to make. And that is, does he file the affidavit saying that Judge Aileen Cannon has actual prejudice or the appearance of impropriety under Section 455 based on the fact that the 11th Circuit overturned her twice back in 2022 for unlawfully asserting jurisdiction in a matter involving Donald Trump, who appointed her in 2020. Jack Smith was waiting to see what Aileen Cannon would do before filing this affidavit, and now Jack Smith has a decision to make, and his decision will be, look, a lot of the rulings in a case under the Classified Information Procedures Act, CIPA, are immediately reviewable to the 11th Circuit Court of Appeals. So do you wait to see if Judge Aileen Cannon makes a number of unlawful orders that she gets overturned again on, and then you ask the 11th Circuit Court of Appeals in connection with a future proceeding, hey, look, she's acting unlawfully here, you need to reassign her. There's a case in the 11th Circuit from several years back called United States versus Martin. In that case, a district court was overturned twice by the 11th Circuit Court of Appeals on an issue of sentencing regarding a criminal defendant, and the 11th Circuit Court of Appeals, which would be overseeing this case, then removed the federal judge from the case as a result of these kind of consistent unlawful rulings. So do you wait until Judge Aileen Cannon makes improper orders and then raise this to the 11th Circuit Court of Appeals, and then basically claim under 28 U.S.C. Section 144 that there's good cause why you didn't raise this immediately or 10 days before whatever the proceeding of the term is, and determining what that actually means here in the context is a little ambiguous, like when is the first hearing going to be? Is it triggered by the order that Judge Aileen Cannon just issued? In any event, if you're Jack Smith, I think you would be thinking in the next few days, you would probably want to be safe filing a recusal motion if that's the path that you're going to do. So Special Counsel Jack Smith now has to decide, do I wait for Judge Aileen Cannon to make unlawful orders, see how she's going to rule? Do I try to file an affidavit claiming that she has actual bias and prejudice now, and then seeing how Judge Aileen Cannon will rule? She'll probably reject it. Then you appeal to the 11th Circuit Court of Appeals. And then is Judge Aileen Cannon going to retaliate against you in all future orders because you tried to recuse her? If the recusal isn't successful, I would think my suggestion would be that Jack Smith and the team file a recusal motion, file the affidavit immediately, file it timely, because Judge Aileen Cannon, I think she's going to make bad rulings, unlawful rulings anyway, and she's already made one by keeping the case in the first place. Now, ultimately here, again, even if this case is before Judge Aileen Cannon, I still feel the case is very strong. I think the case is unimpeachable in terms of the speaking indictment. Yes, can Judge Aileen Cannon do things like try to delay the matter or make bad rulings that could hurt Jack Smith's ability to prosecute this case quickly? I think that she can. However, I think that the case will go before a jury. I think that ultimately Donald Trump is going to be convicted in this matter. He's not going to be acquitted. I think Special Counsel Jack Smith is going to be bringing another indictment very soon as well in Washington, D.C. for Donald Trump's conduct relating to the January 6th insurrection, as well as wire fraud charges. It is also possible that Special Counsel Jack Smith brings an indictment in New Jersey for willfully showing people classified information at Bedminster. So we'll see if that is a maneuver that Special Counsel Jack Smith has. But I think Special Counsel Jack Smith has the toolkits here to deal with this. I think that it was obviously something that they considered when they had to file this case in the Southern District of Florida. That's where the venue is. It's where the crime took place. So Special Counsel Jack Smith could have filed it in the wrong venue. This thing would have been delayed for 6 months to a year. It would have wound up in the Southern District of Florida. So he did the right thing. And those are the facts. That's the framework of the law, and we'll follow what happens next. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers. Check us out at Patreon and wherever you get audio podcasts. Subscribe to the MeidasTouch podcast and have a great day.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.